Hello, everyone. My name is Cat Oriel with Forbes Breaking News, and today I'm here with Stan Brand, law professor and former legal counsel, general counsel to the U.S. House of Representatives. Stan, thanks so much for joining me today.
My pleasure.
So we're here today to talk about the Supreme Court ruling that came out right at 10 a.m. this morning that Trump can stay on all state ballots. So can you give me a quick overview of that case, Trump versus Anderson, what this ruling means, and just your overall thoughts and reactions to the decision?
Well, the ruling itself is fairly narrow in that it holds that no state under the 14th Amendment, Section 3, which has a provision about disqualifying people who've taken an oath to support the Constitution and then engaged in insurrection, may, hold federal office because no state can, in a sense, impinge on the primacy of the national election for president, and that there's nothing in the 14th Amendment that appears to give the states that power. In fact, the entire thrust of the 14th Amendment in the post-Civil War period was to take away and actually intrude on state sovereignty to the extent it provided voting rights and other rights for formerly enslaved people. And so that's the straightforward ruling. The court avoided a host of other very dense questions, including whether the president is an officer as specified under under the third section, whether Trump engaged in an insurrection, and several other issues. They went to the heart of the matter, which was what is the state's power to hold him off the ballot? And they found that that they did not have that power, and that's something that one state, in effect, couldn't throw its weight around and create a cascading effect of states deciding who could get on the ballot for federal office.
Mhm.
So that much is pretty clear from 9 people. The full court agreed with that.
Yeah, and so I know you mentioned that, this is pretty much what you were expecting, but as you said, the court has a conservative majority, so I don't think the ruling itself was a shock, but did it stand out to you that it was unanimous?
No, because although you can't put much stock in what happens at oral argument, because that's a testing phase. That's the court probing and parrying with the lawyers to suss out the nuances and the subtleties. The unanimous consensus at the oral argument seemed to be a very big suspicion about a state's power to do this. So that part wasn't surprising. What was not surprising, but maybe significant, is that 4 justices concurred in the judgment. That is, they agreed with the result, but they disagreed with how far the court went in stating that only Congress has the power through legislation to deal with this issue. The fifth section, I think, of the 14th Amendment does say Congress can enforce this by appropriate legislation. But there was a debate between the concurring justices and the per curiam opinion about whether the court should have gone that far and, in a sense, ruled on something that they didn't need to achieve the result that they did.